All right. Welcome, everyone. You are at the Your Rights and Risks for a Protest with Ohio SB 33. This is a panel discussion tonight, and I have Larry Bresler from Organize Ohio with me as a panelist. I have Gary Daniels, of ACLU, and Tad Pinkston of Pinkston Law and the UU Justice Ohio Board. I am Kristen Vireis, and I am with UU Justice Ohio. I'm community organizer, and I work with Joan. You might have been expecting Joan here tonight. Unfortunately, she's unable to join us, so I am filling in for her, and we're all sharing duties tonight in her place. So to get us started, I have a very quick quote for us from John Lewis. Nothing can stop the power of a committed and determined people to make a difference in our society. Why? Because human beings are the most dynamic link to the divine on this planet. That is from John Lewis. Thank you, Joan, for that wonderful quote. All right, so we are here to talk about SB 33. And before we do that, I would
Kristen, I think you've muted yourself.
there we go. Now I'm unmuted. All right. So Larry Bressler from Organize Ohio, if you would introduce yourself to us so that we can get to know you a little bit, I would greatly appreciate that. You'll need to unmute yourself to talk. And you should be able to do that.
Thank you. My name is Larry Bresler. As you said, I'm the director of an organization called Organize Ohio that works to promote and assist grassroots community organizing. I've been involved as an advocate in organizing around state, local, national issues for many decades. I'm both a social worker and used to be an attorney.
Great. Thank you, Larry. And Gary, would you like to introduce yourself? As our other one of our other panelists tonight.
Yes, thank you. Gary Daniels. My title is Chief Lobbyist for the ACLU of Ohio, which basically means at some point I drew the short straw and I get to go deal with the legislature and the legislators on a regular basis. I've been with the ACLU of Ohio about 22 years. 13 of that has been full-time lobbying at the legislature and seeing these issues come and go and survive.
Wonderful. Thank you. And Tad Pinkston.
Hi, everyone.
Our other panelist.
Thank you. I am an attorney. I have my own law firm, hence the Pinkston Law aspect, but perhaps more importantly, tonight I'm a member of the UJO board. Beyond my own solo practice, I also, and I am not representing them today, but I am a public defender in Lake County as well. So I hope I can bring some expertise as to the criminal aspect of Senate Bill 33. Thank you.
Great. Thank you all for being here. I appreciate that. And those of you who are watching and joining in, feel free to introduce yourself in the chat with your name and any organization you might be with and the area that you're in Ohio or elsewhere. We would love to see those in the chat so that we can get to know you as well. Thank you for being here. All right, I'm going to introduce the bill that we are talking about tonight. You can see it on your screen. I'm just going to basically read the language and what it is. And so we know what we're talking about tonight. The SB 33 was signed into law in January of this year. It is effective as of April 12th of this year, so a little over a month and a half away. It adds new prohibitions under the offenses of criminal mischief, criminal trespass, aggravated trespass, and making false alarms for conduct occurring in or on a critical infrastructure facility. So think pipeline, electric, injection wells, those kinds of places is what we're talking about here. It creates the offense of improper organizational involvement with a critical infrastructure facility that prohibits an organization So that's any organization like a nonprofit or activist organization from knowingly doing either of the following: directing, authorizing, facilitating, or encouraging a person to commit an offense in the first dot point, or a specific type of telecommunications harassment involving a critical infrastructure facility. It also prohibits an organization from knowingly providing compensation to a person for committing an offense in the first dot point, or a specific type of telecommunications harassment involving a critical infrastructure facility. This bill provides for the imposition of increased fines on organizations that are guilty of improper organizational involvement with critical infrastructure facility. It creates a new civil cause of action for willfully causing damage to a critical infrastructure facility. So that is a lot of words and a lot of legalese and a lot of things that I sit here and read this and I think to myself, I'm not sure exactly how that translates to me, to working with you, Joe, and the work we do, to working personally if we go to the state house and we protest. Does it affect that? What if we do go to a pipeline and we are protesting a pipeline, or we chain ourselves to a well? What are the repercussions of this bill, and how can we still get the word to our legislators and city managers and the people that need to hear us? How can we still speak out with this bill in place? That is what we are talking about tonight. I'm going to stop sharing so that we can see our panelists as they speak. I would recommend putting yourself on speaker view so you can see the panelists and myself as we go through some questions tonight. I need to get out of this. Okay. We do have a list of questions for the panelists that I'm going to go through. I'm going to pull those up now. All right. First question. Oh, and I'm going to direct questions to each of you, but you can, pass on to somebody else if you choose not to answer. So that's completely up to you. Question number 1. What do you think are the most important things people should know about SB 33 if they want to avoid felony charges but still exercise their right to protest and demonstrate at critical infrastructure sites? And I'm going to start with Gary.
Yeah, thank you, Kristen, and everybody attending here. The short answer to any types of questions like this, it's always that that joke that's told among attorneys and stuff, that the answer to any legal question is, it depends. And it is certainly true with SB 33 and the ramifications of SB 33. There are a lot of different and nuanced ways that somebody could potentially find themselves violating the new law created by SB 33. And it's really a bill that's divided into two basic, let's say, parts or subject matters. That's increased penalties for civil disobedience, destruction, what have you, of these critical infrastructure sites. And then there is a part that is definitely aimed at discouraging people from protests and demonstrations of all kinds. And over the years, this is not exclusive to pipeline protest bills, obviously a recent trend in state legislatures over the last several years, but this is not exclusive to this issue. We have seen this laws and legislation like this decades ago with regard to, for instance, civil rights demonstrators in the 60s, and we see it now popping up in bills with regard to protests that occurred over the past 2020, let's say, particularly in the summer, that happened in Ohio and many other areas. So we're seeing a lot of bills that are very much like SB 33 being changed and adapted to address that issue as well in many legislators' minds who find that to be an issue. So the free speech part of this, which is particularly troubling, is, and again, we see this not only in pipeline protest bills and similar bills, but other areas of law, is this idea that the language is written so vague enough or so broadly, or a combination of the two, that people in the position of many people on this call are unsure of exactly what it means to be violating the law. So when you talk about that it's aggravated trespass, which is a felony offense here in Ohio, in the context of SB 33, knowingly enter or remain on a critical infrastructure site with the purpose to destroy. Now, that has a certain meaning, and we could probably find a lot of commonality on what exactly it means to destroy something, but it also says not to just destroy, it says, or to tamper with that critical infrastructure site. So what exactly does tamper mean? I think the short answer to that question is a court somewhere will likely decide that sometime in the future, but I realize that is of little help to people who are wondering today, how exactly will we run afoul of the law with regard to SB 33. So again, two main things to keep in mind here is that upping of the criminal penalties, which I think we could all generally agree, I'm sure, on a call like this, that they are out of proportion with the actions or potential actions that can be taken as part of civil disobedience. And then again, this free speech part, that in the free speech First Amendment world, there is a term, it's a legal term as well, about chilling people's speech. And the idea is that you're never quite sure if you're running afoul of the law again. And so you decide not to speak. You decide not to have a protest. You decide not to have a demonstration because it is so unclear that your speech has been chilled as a result. And I'm sure we'll probably talk about this as the event goes on, but there have been some lawsuits filed over pipeline protest bills in other states that talk about exactly this effect, the chilling effect of free speech. So, certainly we'll be talking more about this as the event goes on, but that I hope that's just sort of a little introductory primer as to what's going on here. And again, it's an unsatisfactory response, I realize, as to how to avoid this kind of thing. But again, it depends on exactly what type of action somebody would be taking, and where exactly that action would be, and how serious the authorities think that action is. A simple trespass versus, again, the example, Kristen, that you used, of chaining yourself to something. All civil disobedience, we see this in different types of protests over the years but they could bring very different reactions from the authorities, whether it's the prosecutors, whether it's the court itself. A lot of this stuff is always unknown until it actually happens.
Great, thank you. Larry or Tad, whichever one would like to jump in next.
I'd be happy to go. As Gary was saying, that it's the definitions in terms of infrastructure kind of broad, and they have yet to be defined. But it does, that it's pretty clear that it's trying to stifle free speech, and I suspect that they're going to, at some point, they're going to be trying to hammer down on somebody that violates it. And to show you how outrageous some of this is, it says you can't mar or hurt, various kind of things, including a telephone pole. So theoretically, under this bill, if you taped a sign saying "for a lost cat" on a telephone pole, you could be charged under this new statute. So having said that, many of us who are on this call, I'm sure, including me, have been arrested in our lives for civil disobedience. And usually when we've been arrested, at worst, we spend a couple of days in jail, paid a fine, and then we go on with our lives. Under this one, you could be facing very, very, very serious jail time, very serious prison time. And so you need to think very carefully in terms of what you're going to do. And as somebody who's been an organizer, a community organizer for most of my lifetime, I not only wouldn't be doing it myself, I wouldn't be urging other people to be violating a law that can land them in prison for a year or more. And so at the same time, it's very important to those of us that cared about the kind of issues that were trying to be outlawed by SB 33, that we want to be able to protest, which as an organizer says to me that I've got to be creative. And that we still want to protest, but we may not want to go so far as to chain ourselves as we might have done earlier, or trespass, or do many of the other things that would land us in jail for a long period of time, but still do it in a way that we get our points across, that we're trying to stop. And so my recommendation is understand the law carefully, and continue to do the protests, but do them in a way that you can hopefully get your message across, do what you need to move forward, but don't do it in a way that you're putting yourself or other people you're working with in long-term legal jeopardy.
If I may just put another quick example of something specific that SB 33 does. So, you know, my other two presentators did a really good job explaining kind of how potentially these penalties could be disproportionate to the acts that folks commit. And I think a really good example of this is something they changed in railroad trespassing law. So previously, if you trespassed on a railroad, that would be a 4th-degree misdemeanor. That's right above a ticket, right? So that's a relatively minor thing. You're not looking at much jail time. Very rarely, even if you're convicted of that, you know, and if you have no criminal record, prosecutors likely won't ask for jail time on a 4th-degree misdemeanor. But now, depending on how long you stay or remain, even just remaining on this site, if you meet that criminal intent that Gary went over earlier, you could find yourself with a 3rd-degree felony, which most certainly is well above 30 days in jail. And I think just that juxtaposition of what was prior law and what will be law now kind of shows how drastic this law is. And I just wanted to kind of use that to illustrate that point.
Kristen, if I could, I wanted to add something that I had forgotten with regard to the importance of SB 33 and running afoul of it. This issue of, you know, again, I think the fancy way to talk about it is vicarious liability. The less fancy way to talk about it is, again, not anything new, is this idea that organizations could be held responsible in some way or form. In this case, heavy fines for pull up the language of the bill here. No organization shall knowingly, and I think this was in the language that you had earlier, no organization shall knowingly direct, authorize, facilitate, or encourage a person to commit any of the offenses that are in place with regard to SB 33. So what exactly does it mean, for instance, to encourage someone to do something like this? And there is a history of First Amendment case law out there about, let's say, inciting a riot and what exactly goes into that, and sort of the parameters and factors that need to be there, because the courts do wisely draw a distinction between, for instance, someone, you know, posting on social media or printing an article or a letter to the editor saying, you know, we should burn DC down to the ground kind of thing. You know, courts and everybody is going to see that as a hyperbolic kind of statement that's not going to have, or really shouldn't among reasonable people, have any real effect on a person's actions when you're talking about inciting a riot. But what this does is it really treats all of these situations the same. I mean, when you're talking about encouraging a person to do that, that can mean almost anything. And it is constitutional to encourage people in a roundabout sense, not in too direct of a sense, to commit violence, to break the law, to do any number of things that are at best under question with SB 33, again, because of that language. And if you are a organization and you're worried about, again, somebody coming after you for something like this, SB 33, when you were talking earlier about it, creates a civil action. What that means is that these owners and operators of these critical infrastructure sites can go in and sue you as a result. And if I remember correctly, there doesn't need to be a criminal conviction or anything first for violating the law. You know, they can just, you know, the legislature now has created this cause of action where they can come in and sue you. And for those of you who have been doing environmental activism and similar activism for a long time, you might be aware of that term slap suits. strategic lawsuits against public participation. You start speaking up about whatever, we're just going to sue you into bankruptcy or non-existence. This is really sort of, at least the way I see it, a form of a different type of slap suit kind of animal, where now not only do you have to be worried about criminal penalties and being fined as an organization, but you also now have to worry about that you're going to get sued because the legislature has created this avenue for these corporations to do so.
And I just want to, I'm going to go back to, we're going to move on with that topic right there, Gary, because I'm going to move on to Tad with that, with the next question on that. But before we do that, I personally want to point out, as an activist and somebody who's been in the activist world, the difference between a misdemeanor and a felony is a big life difference for people. And that's a huge choice to have to make between risking a misdemeanor and a couple days in jail with a big fine, to a felony conviction, which can impact whether you can get a job, how and where you can live, and things like that. So I just want to point that out, that to me is one of the big chilling effects of this bill, is that fear of being arrested and having a felony conviction. So Tad, I'm going to throw to you the next question because Gary already started it. What do you think are the most important things nonprofits, organizations should know if they want to still support public witnessed events?
So a few of the things, a lot of this bill deals with destruction and improperly tampering. Now, destruction is something that I think a lot of nonprofits already don't delve their feet into in terms of supporting those types of things. But when it comes to improper tampering, at least the way I read this law, is that can be as simple as moving things. And so that's certainly a broader scope than what, we typically see in these types of laws. And I think the description of it as a slap suit in a different type of a way is absolutely correct. But if nonprofits and activists want to support folks who might have been convicted under this law, I wanted to mention, because one thing that the law prohibits is compensation. So let me read a bit. That means doing things, the way the act defines it is, compensation means money, thing of value, or financial benefit. So you can't do these things with regards to compensating the folks who get prosecuted. So that means folks probably shouldn't be paying people to participate in these things. But one way nonprofits can still help folk and demonstrate solidarity is, this is actually, I want to call it a good part of the bill, but certainly something that is positive, is that compensation explicitly in the language of the law does not include bail, fines, or court costs. So perhaps nonprofits might be able to help folk who are ultimately convicted of these laws, and maybe they're sitting in jail waiting appeal to test the constitutionality of them. That might be an avenue for us to speak our conscience and act to help activists. I don't know if Gary or other folk want to hop in on here, so I'll let them kind of take it from here.
So I guess I'm next. Briefly, I'm not going to talk. Gary and Tad have talked about the ramifications of this well, and so I'm not going to go into that. I just want to mention a kind of little postscript that that Joan Van Beesler, when the committee hearing was in the House, came in and did this wonderful testimony in terms of how this was going to hurt churches if this went through with this, and very, very much impressed the legislators in the committee, enough to the degree that they amended it in the committee, so amended that part and really watered it down considerably. So they said it really did not have a lot of meat anymore. Unfortunately, at that point, they decided to kind of pitch the legislation until the second to last day before the lame duck session ended in December, and they decided, well, let's pass it, but in order to pass it, we have to pass it in its original form. So it passed, and all these and the liabilities to organizations has remained, even though to a substantial degree it had previously been taken out.
Okay. Gary, did you want to add anything else to the nonprofits and organizations, or did you pretty well cover it? I just wanted to make sure.
No, I think the previous discussion and especially what Tad had to offer there, it's certainly if there are questions of people, we can do our best to answer them, but I suspect it's sufficiently covered.
I do see an interesting question in here because you mentioned, Tad, that you could fundraise to get people out of jail and prison, and somebody suggested, might there be a fundraising drive to have the test case as to the constitutionality of the law? Because can we fundraise ahead of time, let somebody get arrested, and then pay for it?
I think Gary had the right of it that there's a lot of things that encourage doesn't cover due to case law, but yikes, that scares me. Fundraising might just be viewed as encouraging, right? So that is because acting as a criminal defense attorney, my job is to prevent folks a lot of the times from finding themselves in these situations. If it sets out alarm bells, my advice is always don't do it.
Don't do it.
Right? I did mention someone also asked about trying to contest the constitutionality of the law before someone ends up in jail. Unfortunately, there's a complicated legal principle called standing. And that means someone actually needs to be protesting a kind of a live controversy. There needs to be someone who was harmed or had their constitutional rights violated before we can challenge it in court. And unfortunately, when we're doing these types of criminalizing speech and protest, that means someone needs to have been convicted most often of the crime that we're trying to fight against and say is unconstitutional. Now, I would say that fundraising to get people out, I think that was explicitly allowed by the act. So I wanted to make sure that point between fundraising for the test case and fundraising to release folks, I think there's a distinction there. But again, this is new. I would definitely consult your organization's counsel, right?
I think to the extent organizations have counsel, that's a very wise advice. Obviously, none of us can provide anything or should not be construed as legal advice of any kind on a call like this. But to add to what Tad was saying about challenging the constitutionality of this, there is a way to go in and file suit without being directly impacted already. These types of constitutional lawsuits typically fall in one of two buckets. They're called facial or as applied challenges, and that's not heavy legalese right there because they are essentially what they say. A facial challenge is you're challenging the law on its face. You're saying, look at these activities I or my organization do. Of course, we are going to eventually run afoul of the law or be prosecuted for it. So before any of us are even tagged with violating it, we want to go into court and challenge the constitutionality of it. An as applied challenge is exactly like Tad was talking about. Somebody has been nailed for it, and you've got a criminal offense, or maybe you've been sued over the civil suit part. But it's actually impacted you. And now, see, the problem is that I'm going to contradict myself here. I realize the problem is that over the last couple decades, the federal courts and the Supreme Court, they really don't like facial challenges to laws because it's all hypothetical at that point, particularly if you're dealing with a complex law with a lot of different areas and, again, nuances where you might possibly violate it. They really want to deal with as applied challenges where there is something to really chew on there. Now, here's where I contradict myself. I know there have been at least two lawsuits on pipeline protest type bills, one in South Dakota and one in Louisiana. The South Dakota bill filed by the ACLU of South Dakota and others, that was a facial challenge. So they did indeed go in and do what I say that courts and judges really don't like to do. But they filed suit, and in that suit, at least with respect to the speech part of the bill, riot boosting is the shorthand term for what a lot of this is called. That was successfully settled. So South Dakota no longer enforces or tries to enforce that area of the law. On the other hand, sometimes these cases take an awfully long time to sort out in court. And so the Louisiana law was filed, I don't know, was 7 months ago, 9 months ago, something like that. I mean, they just had a motion to dismiss that was decided like back in October. That was the most recent update I could find. Suffice to say that Louisiana case will probably be going on for quite literally years because that's how long it takes many times for these types of things, unless there's a settlement. So, it's how exactly someone might violate the law, what they might be charged with, really goes to how successful a lawsuit may or may not be. And I will say this as well, that people should realize, I know that with these other lawsuits, it appears, at least from what little bit I dug up about it, that some national organizations are sometimes involved. I don't know, in the litigation part of it, providing advice, they were the protesters, any combination of those things, I'm not sure. But the benefit, if there is any benefit, of these types of laws that get passed around the country when it's a trend, and there's other areas of law and policy where this happens: abortion, voting rights, a whole bunch of other types of things. But the advantage is that you can craft sort of a national strategy, a long-term strategy to get these laws overturned. And when there is enough states passing these laws, you can almost start to pick and choose for those laws that have the worst language and hopefully make them the easiest to challenge. Maybe they are in an area of the country where the courts are perhaps historically a little bit more favorable to lawsuits such as this. Maybe there's particularly good case law in that particular court or appellate court area. So people do strategize this way when you're talking about a long-term way to combat these types of laws, is starting with the worst many times, get those knocked out, try to build up some good case law, some good language you can point to saying this or that is unconstitutional. So for all I know, and I do not know, but for all I know, that is exactly the type of strategizing that's going on with these particular lawsuits. Now, Louisiana stemmed out of a criminal conviction of people actually being nailed for violating the law. So that's a little bit different. But in many other areas of the law, again, when you sort of can pick among many states where to file a lawsuit, many times there is a larger strategy in play here by litigators and organizations around the country.
Tad, I'm going to come to you because we also I wanted to get your thoughts on this, because we have a question in here that Gary has also jumped into. Do you have any thoughts on whether organizations would be supported if someone or some organization were deliberately to violate SB 33 to test it? And would the person or organization be convicted? What are your thoughts on that, Tad?
So I don't think that let me kind of parse that a bit. So I don't think that if someone's convicted and organizations come to that person's aid and they try to support them either financially through getting them potentially out of jail or raising awareness about the kind of injustice that person received. I think, based on my reading, that, and again, I'm not trying to give legal advice. Please consult your own attorneys if this ever happens.
Yes.
But it seems to me on my reading of this that that's perfectly fine. That's protected speech, right? You're criticizing law. That's what the First Amendment is there for. And you're using a person's story in order to illustrate why a law is bad. That's absolutely fine. And I think there could be lots of national organizations, kind of like Gary was talking about, who will be crafting nationwide litigation strategies. And of course, they'll be supporting each other and supporting folks who want to try and present these type of test law cases. Now, if it comes to financially supporting someone to then violate the law, that's where it gets a little trickier. And that would really depend on a case-by-case basis. But this law, I think, is designed to try and prevent that kind of explicitly. I don't think there's really two ways around it in that respect. It's broad and vague in some areas, but that vagueness and that broadness serves a purpose. And that purpose is to try and stop these types of protests, in my mind. And I think that's also what makes it so potentially unconstitutional. But I think that is its purpose, and it tries to effectuate that purpose. I don't know if Gary or Larry want to hop in on that, but I think that's my final word, at least.
Okay. All right, we're going to go on to our next question. So I know we've talked about other states doing this and how this is a big deal. Why do you think SB 33 was passed in Ohio? And what is going on in the legislators' heads? Larry, I'm going to start with you on this one.
Okay, I don't think you can't distinguish in terms of why it was passed in Ohio versus other states, because I think you need to understand why it came to Ohio to begin with. And so it came as a result of legislation that was drafted by an organization called ALEC, which stands for American Legislation Exchange Council. American Legislation Exchange Council is an organization that's composed of very conservative legislators, state legislators across the nation, along with big business, parts of big business. It was started and was funded substantially by the Koch brothers, and their purpose as an organization is to draft and promote and get passed legislation across the country that supports business interests and in a conservative business interest at that, across the country. So, in terms of SB 33, that was drafted, as I say, by ALEC with the intent of making sure that there was no more standing rocks that any place across the country, and that they want to stifle the kinds of environmental activism that was starting to build, not just in Standing Rock, but every place else. So then their purpose was to find legislators that would introduce it. They found legislators that would introduce it in Ohio. They found legislators that would introduce it across the country, and it was introduced in one state after another. So just to give you an idea, laws similar to SB 33 were passed in Louisiana and Texas and South Dakota and North Dakota and Oklahoma and Iowa and Indiana, Tennessee, Missouri. I could go on and on. As Gary was mentioned earlier about it being challenged in Louisiana, I think part of the reasons why it's being challenged in Louisiana, is that at this point, 16 or more persons have been charged with felonies for, I believe, trespassing on pipeline there, and so it obviously requires a challenging. So yes, there was a concern, there was an interest in terms of being passed, particularly in terms of making sure that places like the power plants were, interestingly enough, the head of the Utilities Committee in the House, that's his district, as well as other fracking, other environmental things that are going on. It was to protect that, but it never would have happened if it hadn't been drawn up and pushed by ALEC.
Tad, Gary, do either one of you want to jump in? And we do have the follow-up question to this is also about national other states and what you know about other states.
I'm sorry to kind of jump in on that.
No, that's fine. Let's combine them because we've already started that with Gary too. So let's just combine that with, what do you know? Also, besides being passed in Ohio, also what's going through the legislators' heads, and what about laws in other states, and what do you know about them? Who wants to jump in next on that? I know Gary already highlighted some and Larry did too, but what about Ohio too? Tad?
So I guess, I'm less familiar with the national strategy since I've been focusing pretty primarily on Ohio state politics. But I think what I was saying about this law being targeted to prevent protests and civil disobedience from affecting folks who have a stake in potentially fossil fuels, right? And it's a lot broader than just fossil fuels, this bill. I don't mean to just characterize it as preventing that, but I think that's a large part of it. It reminds me a lot of those laws that were passed in very many states about people recording things in slaughterhouses. Now, obviously, there's no recording provisions in that, but I think the attempt to stifle activism is certainly in the legislators' heads when they, use this ALEC type of legislation and maybe even put their own tweaks on them, right? So I think my prior points also apply to the national conversation as well.
Yeah, I think both Tad and certainly Larry covered, it's the idea when ALEC does what they do, which is try to get bills introduced in state legislatures, they usually don't have to go looking very far. It seems there's a lot of state legislatures and legislators out there that are happy to carry some sort of bill. And my suspicion in having dealt with a lot of bills and negotiations, things of that nature, is that whatever model bill is out there for this, and I have not seen the model bill, but obviously you see a lot of the same language pop up from state to state, very similar. Some's worse than Ohio. Certainly where those lawsuits were probably worse than Ohio. Some are probably slightly better than Ohio. There's a range there, but what I think is that ALEC and whoever adopts the bill and runs with it in their own state legislature purposely write a pretty extreme bill. And they do this because in the grand world of legislation and legislators and negotiation, the expectation is that if they improve the bill in any regard or whatsoever, then it's time for everybody then, made some compromises here and there for everybody. It's time for everybody to get on board and support it, or at least be neutral on the bill. So when you write a bill that's extremely extreme to start with, and you improve it, knowing that you're going to improve it all along, you're really no worse off than when you compromise some things away, because you're getting at what you're hoping to get at anyway. And I think that's exactly what happened with this. I mean, I first became aware of this bill when it was, I think, Senate Bill 250 a few years back. And at that point, the bill included specific language about impeding or inhibiting a critical infrastructure site. And I was able to work with the committee chair in Senator Hoagland's office to get that particular language taken out of it. But no surprise, as I was looking into what some other states are doing with this, I saw that a state passed a pipeline protest bill with the words impede or inhibit in it. So even if we didn't know specifically, like ALEC gets accused of a lot of things, rightly so. I don't know if they're quite responsible for everything people accuses them of in state legislatures. In this particular case, Larry has it exactly right. There are fingerprints all over this directly tying it to ALEC. And I will just say to close on this part, I do state house trainings for people around Ohio. I've been doing them for a number of years, sort of, so some of you are familiar with other people that do the how things work at the state house programs. They're all basically the same type of thing. I know them, they know me, and we go around and do slightly different versions of this. But I always do a version where, half of it is essentially, this is how things work. This is how bills get introduced, basically how the machinery works. But the true answer of why these things happen and how they work is, well, I mean, just look at House Bill 6 and First Energy and everything that happened, over the last several years with that, and continues to happen with that. That is how things really work. So despite, how committees go and how to testify and everything else, when you see something like House Bill 6 or SB 33, they're all part of the spokes of the same wheel, that you get enough influential people with enough money behind it, and you're not going to have much problem finding legislators who will introduce that bill.
One quick thing, very quick, one sentence thing, or two sentence. One of our state reps in Ohio, a guy named Bill Seitz, a very conservative Republican in Cincinnati area, is on the board of ALEC, and he wasn't a sponsor of SB 33, but he is a sponsor on one of the successor bills, SB 109. I mean, not HB 109, which we're going to talk a little bit about later.
Yeah. Thank you. All right, next question. What can activists and organizations do to have SB 33 revoked or rescinded? Is there anything that can be done at this point? And I'm going to toss that one to Larry first.
Well, and I'm not going to take long because there isn't a whole lot we can do. We can challenge it legally, which has been talked about in detail. You can always the idea of doing any kind of a referendum or appeal on it costs a humongous amount of money, and that isn't likely to happen. And I wouldn't bank that we're going to get our current legislature to introduce a repeal of the repeal. So I think unless we deal with it from a legal perspective, we're going to have a hard time. We're going to have a hard time doing anything to rescind it.
Chad, Gary, either one of you want to jump in?
Hit it absolutely on the head there, Larry. I think that's precisely correct.
I can hear my friends in my ear, imaginary sort of in the voting rights and election world, screaming gerrymandering and and redistricting and everything, because it's like when your ears burn and somebody's saying that somewhere. So yeah, perhaps long term that could certainly help with this. But I can't imagine the legislature with a bill that they just passed entertaining any kind of on their own passing a new bill that undoes it.
And I would like to get just a little bit more clarification on a few terms that come up through this bill, if you guys don't mind. And this can be popcorn, whoever wants to answer it. Can somebody do a quick definition of critical infrastructure so we can I know there've been some questions in the chat about what is defined as critical infrastructure. Is it working wells or not working wells? Are we talking about pipelines that are coming, pipelines that are there, pipelines that have been removed? What are we talking about here? Can somebody do a quick definition for me? Was that you, Larry? Were you going to jump in or?
Well,
no?
not really, except to say that there's a whole listing of what critical infrastructures is in the bill. It goes on for about 3 pages, but even then it's kind of as Gary was mentioning earlier, it still is very vague. So I'm not going to be able to define each one specifically is going to be, that's part of what's going to eventually need to be challenged legally.
Okay.
Yeah, I just did as a result of the question, I have the bill pulled up in case a question like this would pop up. And so, I don't know the bill now law or soon to be enacted law backwards and forwards. But it looks like there's at least 19 definitions for that fall, 19 things, let's say, for lack of a better word, that fall under a critical infrastructure site. I don't, at a quick glance at this, see anything that says, whether they have to be working or not. Certainly I could see something like that, that kind of fact pattern, having some sort of impact on a prosecutor's decision or a judge's decision as to whether to bring charges or uphold convictions or what have you. Who knows? A lot of times this depends on what court or what judge. But looking at it real closely, it doesn't seem to me, I might be wrong, it doesn't seem to make that distinction between working and non-working. And if you want that, that full slate of definitions, that language is available out there. But it does cover all kinds of different, corporate entities, natural gas, chemical, polymer, petroleum, water intake structures, telecommunications, wireless telecommunications, railroads, all kinds of things.
And I see Tad just copy and pasted some into the chat. So for those of you who are watching the chat, there's a short list for you.
Right. So that's just the first 4 things. But as you can see, even those 4 things, while being kind of long, are particular, but they're like a petroleum refinery place, right? And it's kind of large sections of things we're dealing with here on each subpoint. And so it really does cover quite a lot of things. And I just wanted to put like the first 4 subpoints in there so folks can a better idea of what that might kind of look like. But as Gary said, the language is out there now. And I'm sure if folks want to follow up email, perhaps we can include that language in there.
Okay, thank you. All right, so we've talked a lot about SB 33 and the implications of that. This is not the only bill that is around in the state of Ohio. There are other anti-protest bills similar to it that are floating around. So I want to ask our panelists tonight, because SB 33 is done and over and it's going through. And as you guys said, there's not much we can do about it, unfortunately. So I'd like to just bring up very quickly, what about SB 16? And what parts are important for us to know? And do you think it will pass? This is also an anti-protest bill. It's very similar to SB 33, only it expands it beyond infrastructure sites into any protest. Similar higher fines, felony convictions, all of that for any protest now. So I'd like to start with Gary on this. What do you think about SB 16 and what parts are important for us to know? And do you think it will pass?
Yeah, so the legislative, we've started a new legislative session. They have only been introducing bills for the past few weeks, maybe a month or so at this point. But they've introduced a lot up to this point, and they have introduced several that have to deal explicitly or implicitly with what happened with protests over the summer. That's what they are aimed at. And so some of them are big and dense and complex, like SB 16, and some of them are much narrower, but they're all trying to get, again, at sort of the same thing. SB 16, it's a Republican bill sponsored by Senator Schaefer. He also has a few other bills that he has introduced of this type, some of which I have not, and I mentioned that they've only been introducing bills for literally a few weeks now, because with the number of bills that have already been introduced of this type, I certainly haven't read through them all, but I'm very familiar with SB 16 and House Bill 109, which was just introduced last week. It's not even a week old yet, I don't think. But it is sort of a lighter version of SB 16. It doesn't go as far, but what is problematic, there are problematic provisions in both that overlap. And what essentially they do is kind of curious the way they do this, but what they kind of do is piggyback upon Ohio's riot laws, aggravated riot and riot. Now, I realize that when people hear the word riot, they think like buildings being burned down and, a post-apocalyptic scenario kind of thing. But Ohio's riot laws are written very broadly. It's basically for aggravated riot, which is a felony offense. It's basically, if I'm operating from memory here, 5+ people who gather to commit disorderly conduct, or in the course of committing disorderly conduct, commit a felony. I see somebody with the 4 fingers there. I get confused about that. It says like you and 4 other people, which is why I always say 5, just because in my head I keep always going back 4 and 5 too. Whatever the case, a handful of people that again, aggravated riot, it's a felony, you're gathering to commit essentially a felony offense. Riot is misdemeanor. That is where you and 4 or 5 or however many other people are getting together to commit a misdemeanor offense. So it's all tied to that, or much of it is tied to that underlying offense. And then what it does in SB 16's case is it amends or expands or modifies 9 current criminal laws and creates 4 more, and then also creates a civil action of the type we were talking about with SB 33, where law enforcement or first responders can come in and sue. For instance, if somebody files a false complaint against them that, at least under the law, says that they know to be false. Again, I think we're talking about getting into some chilling of speech areas again. Some of the bill has to do with actual assaults against first responders and upping the penalties for that. And it is a cousin of SB 33, again, in this issue of holding organizations responsible. And I think for the purposes of this call, in the broad interest of people engaged in activism and civil disobedience and being parts of, whether it's a nonprofit organization or a citizen group or even an individual, it does this thing where it amends Ohio's corrupt activity laws. And if you get, as far as I can tell, if you run afoul of Ohio's corrupt activity laws as an organization, you can be shut down, your assets can be seized, the board of directors removed, you can be fined, all of these various sorts of things. So what it does is it in SB 16, it inserts this language about organizations or people that provide, quote, material support or resources to facilitating, organizing, what have you, a protest. And I'm familiar with that term, material support and resources, because at least when I first became aware of it, was it being used in an anti-terrorism context in federal law. And there's a long history of exactly what material support and resources means, or does not mean. But what we're now seeing is this language that's intended for anti-terrorism laws being used in these protest bills as well. And SB 16 does not define material support and resources, unlike federal law in Ohio state. Ohio has material support and resources, again, in its own state anti-terrorism laws. So, but SB 16 doesn't even have a definition. And I know when this is brought to the attention of legislators, their answer might very well be, oh, well, let's just cut and paste it from the anti-terrorism section over here. And that's, suffice to say, not appropriate, because people who, for instance, you are committing a riot, as far as I can tell, under the language of the law, if 4 or 5 or however many of you block an intersection during a protest in a street for 15 minutes or a half hour or whatever. Technically speaking, excuse me, that is a riot. So if other things happen as a result, you can run afoul of SB 16. House Bill 109, though, might worry me a little bit more, because I'm not sure if SB 16 is going to pass or move. It had this week proponent testimony, and a lot of the first responder organizations are supporting this. The chiefs of police, the Ohio Prosecuting Attorneys Association, fire, medical, et cetera, et cetera. I don't think they essentially know a lot of what's in the law. I don't think they're going in there with the intention of like, yeah, let's shut down these people through Ohio's corrupt activity laws. But because it's a dense, complex law, and because there's new leadership in the Senate, it remains to be seen whether this bill of Senator Schaefer's has any actual legs to it. Worth keeping an eye on, concerned about it. It's already had 2 hearings that may continue. House Bill 109 is sponsored by, among another legislator, as far as primary co-sponsors, Representative Abrams, just like last session's House Bill 784, which you might recognize. She's a former police officer. My guess, with no particular intel, is I'm a little bit more worried about House Bill 109 with similar provisions passing, but who knows? I mean, you can go broke trying to forecast and bet on exactly what the legislature is going to do, particularly right now when there's been a lot of turnover in leadership and in the legislature itself. So those are 2 of the big bills on police and protests I think are worth watching, but there are some other, I don't want to say smaller ones, because they're serious bills as well, about having to pay back costs of police protection, all these other sorts of things, and taking even a smaller slice of House Bill 109 or SB 16 and making its own bill. Suffice to say, I think we're going to be dealing with bills of this type throughout the entire 2-year legislative session here in Ohio. And my sense is that, just like with SB 33, some version or another of this is going to ultimately pass. But hopefully through all of our collective hard work, we can prevent that from happening. Or if it does happen, that it is not as horrible a bill or bills as they are right now.
If I can just add to what Gary was saying, first of all, going piggyback in terms of 109 being more concerned, I'm very concerned over both bills and concerned over 16, because right now it's going through the process, and we have to do everything we can right now to stop that one. 109, I'm also very concerned about, just for the reason that the people that the sponsors and the co-sponsors of it include 2 people from the House leadership and 4 people who are in the Criminal Justice Committee where it's being heard. So it's got a lot of legs. It makes me worried that it's really wired. But I want to talk for a minute about 16 in particular, even though 109 is very similar, because it's being heard right now. And just a couple of examples of what it would mean if it was passed. Just to that again, as Gary is saying, if it's as a riot, and you were blocking a street, or you're doing a sit-in in a school, or or for example, the state office building, you're doing a sit-in there and they ask you to leave and you don't, you can be you can be charged with a 5th-degree felony, meaning you could receive a year in prison and $2,500 fine if this is passed. Likewise, if organizations who support the protests could even be under worse circumstances, and I'll give you a couple examples what that would mean. As it says, it's because people are supporting what's determined a riot, and a riot is very, very loose. One of the things that's in the riot statute is if 4 or more or 5 or more, however, people start yelling profanities, you can be charged as part of a riot at one time. So let's say SEIU as the union is doing a demonstration over something. The police come and 5 of the people there start yelling profanities. SEIU leadership could be liable as a 2nd-degree felony under this bill. Likewise, that with the May 29th Black Lives Matter protest in Cleveland, which when that happened, you had people breaking off and doing all kinds of damage at the time. It can be argued that maybe Black Lives Matter should have foreseen that because it was happening in other places, and they could be responsible for compensating for the property damage under that bill. And people who are organizing people to do this. If you're an organization such as this example, the Ohio Porpoise Campaign, and the leaders there help to organize a sit-in or organize, when we blocked the street way back, its leaders could be charged with a felony as well as a $15,000 fine. So talking about stifling free speech, this bill is horrible in that regards, and it was predictable. We all knew when SB 33 was coming up that was only going to be the beginning, and now we have the second act to it.
My co-presentator said literally everything I wanted to add on both of those fronts. I was going to kind of focus a bit on Senate Bill 16. I kind of covered that a bit in the legislative update that UDO hosted a while back, but everything I wanted to discuss was covered. So I really have nothing more to add. Thanks.
Great. Thank you. Great information, everyone. I appreciate it. I am going to say, I know there's a lot of questions in the chat and everybody's worried and concerned. I hear a lot of, we're concerned about this and what do we do and how do we handle this? So I'm just going to share with you what next steps might be for all of us. So we have to get talking to our legislators. This is the point where we start yelling and screaming. You already have SB 33. This is worse. This is going to take it beyond that. SB 16 is another part of this, more of this human rights violations, more of this taking away our free speech, all of those things. We are doing tomorrow night at 7 p.m. We're going to do a testimony and letter writing party where we're going to review SB 16 and HB 109. We'll look at some of these smaller bills as well. We're going to talk about the talking points. How do you talk to your legislators? How do you write to your legislators? How do we put this into words to explain to them that this is not what the people of Ohio want to see? It is a violation of our rights. So we're going to be talking about that tomorrow night. We're also going to look at the process of writing opponent testimony statements. So we expect that on Tuesday at 3:30 p.m., we expect the State House to be hearing Senate Bill 16 opponent testimony. We need to get written testimony in the hands of all the of the committee so that they can read that and hear that at that hearing. So we're going to be talking about getting things ready for that, helping you get your points together, helping you figure out how to write it, give you the tips, the toolkit, and everything to help you do that. We don't have a schedule yet for HB 109, but we will be holding another writing party later to help you do that. If you miss this one tomorrow, we will be helping with HB 109 to help you get talking points for that. We're going to look at how to turn testimony statements into letters to the editor and submit them to local newspapers. There's going to be legislative letters as well. So we'll help you write it all down and turn it into everything that we can splash the world with in Ohio to get the message out that this is not what we want. And we'll also take key elements of our testimony statements and use them to write letters and emails and make phone calls to our Ohio senators and reps, especially the House Criminal Justice Committee, who's going to hear HB 109, and the Senate Judiciary Committee, which is hearing SB 16. The link for that is, I am maybe going to put that into the chat. I'm going to have to pull that over here so I can do that. I will put all these links, I'll put that in the chat. That is tomorrow night, our Writing for Justice workshop. And I'm posting that now so you have it and can register for that. There you go. Here's some resources for you as well, which I'll put into the chat so that you can copy paste and use those. Analysis of SB 33, Ohio ACLU, thank you. Know your rights for protesters. This has not been adopted since SB 33, and it doesn't, at this point, we don't expect it to be adopted because at this point, I think it covers it. The National ACLU has also put out protesters' rights. So if you've never looked at either of those are really helpful for you to look at to help you stay in line, to help you be able to do protesting and do it in a way that you hopefully won't get arrested for it. They keep making laws up to try and get us arrested for it. And the Ohio Resistance Guide for Ohio activists to also help you organize and still be able to go out and protest despite all that is going on in our state house. And I have one last quote for you. Take a long, hard look down the road. You will have to travel once you have made a commitment to work for change. Know that this transformation will not happen right away. Change often takes time. We need to put energy into it. It rarely happens all at once. The struggle for change is not a struggle that lasts for a few days, a few weeks, or a few months. It's a struggle of a lifetime, and that is also from John Lewis. I am going to go ahead and stop the recording. Thank you all for being here. This has been a great discussion. Lots of wonderful information. Really appreciate it. Thank you all.